What's up, everybody? Welcome to WN420 TV. I'm Lance, and today we've got a very special guest, Pat Nolan from Pat Talks Law on YouTube as well as on Facebook. He's one of Missouri's premier attorneys, and he's really stepping up to help us talk about and defend the rights of, well, medical marijuana within the state. There was a comment from the Missouri Supreme Court in suggesting that attorneys can't have anything to do or shouldn't have anything to do with making comments or advising within the medical community. Pat, how are you doing, man? Welcome to the show. Thank you for taking the time out to be here.
Good, thanks for inviting me.
We've got just a few questions about this comment today, and I was hoping maybe you could help clarify it. You did a really good job in your video that you released last week. I guess we should start off with the first question, and it's, is this comment a ruling, or can it be perceived as such?
That's actually a great misunderstanding that a lot of people have. Not great that there's a misunderstanding, but it's a great question because of the misunderstanding.
Right.
The way our attorney rules work, the Supreme Court promulgates rules. Those rules are dated, they're on the Supreme Court website when they were last changed. The comments underneath them are clarifying. They're designed for the attorneys to know how the court is going to look at conduct, how to conform to the rule. So in this case, the Supreme Court issued comment number 8. And it's my understanding that was this past summer, despite having been led to believe it was recently. So this past summer, they issued comment number 8.
So this comment has been on the books for a little while. It's not something
that
just randomly popped up.
Yeah, 6-7 months.
All right.
We found that out after talking to other attorneys who have tracked it. And I guess as a preliminary matter, I know that you're aware of it, but there was a meeting here just the other day with leadership of Missouri Normal, the Canna Convict Project, Canna Matriarchs, Missouri Cannabis Network, the Missouri Association of Criminal Defense Lawyers, and various cannabis law firms and attorneys. And got together and we discussed the rule and how it's going to impact everybody and what we as attorneys and advocates need to do to address this. And as a group, we reached a joint statement, and if I may, I'll just read that to you.
Sure.
Missouri attorneys and advocacy organizations are working diligently to obtain clarification from the Missouri Supreme Court regarding the addition of comment number 8. A formal opinion has been requested from the Missouri Supreme Court Advisory Committee to clarify how and if the Missouri medical marijuana program attorneys and patients will be affected. At this time, these organizations do not believe that patient rights will be impacted by this comment, and the legal representation of medical marijuana patients will still be available. However, we don't intend to let this decision go unanswered, and we're going to continue to pressure the state to uphold the constitutional protections of medical patients and attorneys. And an updated statement will be provided upon receipt of a response from the state. Now, thank you for your patience and understanding. So
that's pretty cool.
We are addressing, and there's a lot of organizations that are coming together and going to be addressing it more in mass. A single attorney obviously is going to be hanging out in the breeze. So, but understanding the difference between the rule 4-1.2 and comment 8, which is a clarifying comment. That's guidance on how to interpret the rule. So, you know, the rule might be, brother, you can't wear a knit stocking cap indoors.
Right.
But the guidance, the interpretation might be, well, if you're only coming in and out the door briefly, you're not actually taking off your jacket, then, you know, that would be one of those excusable exceptions. That would be the comment to the rule. However, in this case, the comment was a pretty stringent comment. Okay, the comment says essentially that attorneys may not advise clients on how to violate federal law, even if they're advising them how to comply with state law. under our Constitution. And I know you have the full text and be putting that up,
Right.
but essentially the comment is not the guiding text of the rule. The comment is guidance on how to interpret the rule.
So I guess that brings us on to the next question, which, how does this comment play with the rules? Which, if my understanding of what you're saying is, it essentially kind of doesn't play with the rules. Is that right?
Well, no, they go hand in hand a bit. It's kind of like a hand in a glove.
Okay.
Okay. The rule would be the hand without the glove. The comment is helping the glove do what the hand is supposed to be doing.
All right.
So while the comment is not a binding rule, the comment is guidance on how a rule will be interpreted.
All right.
So without that, we might continue to think that the Supreme Court is going to honor the Constitution and follow the law of the state of Missouri. However, with the comment, we know that the Supreme Court may not follow the Constitution in this case.
Gotcha.
And the Constitution is a guiding document that creates the Supreme Court.
If the Supreme Court isn't going to follow the Constitution under this setting, are they going to follow the rules under different settings? Or is that something that we should be concerned about?
Yeah, we should definitely be concerned about it. Unfortunately, this isn't new for the Missouri State Supreme Court.
That's fair.
In 2016, 17, the Supreme Court issued a ruling holding that it was Amendment 5 in, I believe, 2014 that created Article 1, Section 23, our gun rights protection in the Missouri Constitution.
Right.
And the Supreme Court held that that was basically a nullity. There was a couple of cases that were argued before the Supreme Court, and they held that the felon in possession law stood even though our constitutional amendment would have stricken that down and allowed felons to have, non-violent felons, to have their gun rights restored. So, and the Supreme Court said, no, we're not going there.
Working with them, it's not always clear cut.
You know, sometimes you just don't know if they're going to follow the actual text of the Constitution or if they're going to go on a trend and substitute some of their interpretations. And on that case, let me say, the dissent by Judge Tiedelman is wonderful if somebody wants to go back and look at it.
Definitely.
But as far as medical marijuana, this is a real concern, and that where that rule and the comment are concerning is the comment signals that the Supreme Court doesn't consider itself bound by the Constitution as we passed an Amendment 2 that became Section 1, Article 14. So Section 1, Article 14, Section 1.5 has protection for attorneys in it, that we're not subject to discipline for advising somebody to follow state law, even though marijuana may be illegal federally. So what we can also take is they haven't actually disciplined anybody.
Right.
So when you look at that and they haven't disciplined anybody, then in the past 6 months, that could be a signal that they're not going to. It could be that it was a cautionary note saying, hey, you guys need to pay attention to what you're doing. You're starting to skirt the edges of acceptable behavior. And we just don't know. That's why, as a group, that clarification has been requested.
So
I know we mentioned Dan Viets earlier. He's a part of that group that got together, and he sought that clarification out. He also helped bring this issue to light for a lot of other attorneys. I just happen to have a big mouth, and my video went all over it.
Another question that just kind of randomly pops in is, how do you think this would affect the appeal process of many of the operations that are under that right now?
Well, that is actually one of the really big concerns that those attorneys have. A number of attorneys have said that they don't think it's going to apply because they're not assisting the companies in applying for a license. And they're not assisting the companies or advising them in setting up their operations, but rather they're assisting them in an administrative hearing process, which is arguing that the state denied a state license inappropriately,
Right.
that the state didn't follow its own procedures. Now, look, we're attorneys, man. We'll shave any hair. So whether or not that will hold water is a different question. It might not. But as far as if they were going to enforce it, I think they would do it sooner rather than later, because there's a lot of money being spent on both sides. The state is spending a lot of money too.
Right.
And the same
Anyway.
argument applies towards the state attorneys. You know, the attorney advising DHS on how to set up and implement a medical marijuana scheme that's in violation of federal law is in violation of this comment's interpretation of the rule, and they would be subject to discipline as well. So
Gotcha.
there's a great big conundrum that this comment creates a huge question that's going to impact not just the industry attorneys, but attorneys on the state side, attorneys that think they have nothing to do with medical marijuana,
Right.
planning and zoning attorneys, attorneys representing cities and municipalities that are members of the Missouri Municipal League, that participated in zoning hearings on
And
whether or
realty
not a
attorneys and
dispensary
stuff.
got a permit. Attorneys that do commercial law, you know, providing materials or selling materials to a cultivation facility or dispensary, and then they file their UCC ones so that they have a lien on that property while they're being paid. Is that attorney that files a UCC one furthering the medical marijuana business? Well, there's an argument that they are, even though they might not even be working for that medical marijuana company. They're working for the company that supplied those products.
Right.
So then you have tax attorneys, and this also goes beyond medical marijuana and marijuana law as well. If the tax attorney is advising somebody complying with Missouri law, but a portion of that tax code would be a problem under federal law, are they in violation? Even if it isn't a marijuana case.
Right.
So, and advising them in regards to marijuana law, medical marijuana, industrial hemp, before we had the full broad legalization federally of industrial hemp. Are those attorneys exposing themselves? How about the attorneys that acted under the belief that they were acting in compliance with the rules before this clarification was posted? So all the attorneys that advised applicants going into the application process, are those attorneys in violation? Because a comment is not a rule change. The comment is a clarification on how the rule will be interpreted. The
Very
rule
much
was
so.
the same. So now, should they be concerned that they have an issue? One thing that attorneys have is a duty to self-report if they violated rules. Should every attorney that has had anything to do with Missouri medical marijuana be self-reporting? Failing to self-report is in itself another violation of the rules. So you've got a huge conundrum right here.
This
Are
is
we in
a
violation?
very, very massive hole, and it's very encompassing. It affects a lot more than you see with the naked eye. How, or does it affect the patient? What impact would it bring towards the patient?
The patient, almost none.
Right.
You know, nobody in Missouri is talking to a lawyer before they go get a patient card.
Exactly.
They're going to go talk to a doctor.
Now, if you are a caregiver, you might be talking to an attorney beforehand. So
Great point.
could this affect them?
Caregiver may want to talk to an attorney to get a contract, make sure they're protecting themselves with the patients they're working with. Caregivers that are charging will probably want to do that to make sure they get paid and they don't get stiffed.
Right.
You know, then there's landlord issues, property rental issues, liability issues. Those are all issues that a caregiver may have wanted to talk to an attorney about. Realistically, under this comment, I don't know that an attorney can talk to them about that. while their actions are perfectly legal under state law, under federal law, they're still distributing marijuana.
What would stop them from, say, reaching out to an Oklahoma attorney that might be familiar with Missouri law?
An out-of-state attorney would not be able to advise somebody on Missouri law if they're not licensed in the state of Missouri.
And then if they're licensed in the
Called
state of Missouri,
unlicensed
they fall
practice
back
of law.
under the previous comment and ruling. And
Right.
gotcha. So this comment doesn't affect the patients, but it does potentially affect the industry, but they're not necessarily actively doing anything about pursuing or punishing any attorneys at this moment.
I want to qualify that last part. Just because I'm not aware of their actively bringing attorneys up in the disciplinary process doesn't mean that they aren't.
Okay, gotcha.
Generally speaking, though, when attorneys are facing disciplinary process, somebody talks. They always do. Attorneys are like, high school girls, man. We talk about everything.
It's a hen house, huh?
Not about client things, but about the industry and about the issues.
Right.
So yeah, I would think we would have heard if somebody was facing discipline for this, but that doesn't mean that they are or they aren't. We just don't know.
I understand that. This is just a comment. It's not a ruling. That's what we can take from this at this point is it's a comment. It's not a ruling. It's there to help advise and guide on the way the motion works in this cannabis ocean, right?
Right. This comment is not a change to the rule. It's a clarification comment, and it has scared the hell out of a bunch of attorneys.
I'd say so.
Now,
it's definitely woke a lot of people up and got people talking.
it is not going to impact, the guy that gets picked up with a dime bag in his pocket. It's not going to impact criminal defense attorneys. They're still going to be able to provide criminal defense work. There was a question early on as to whether or not they would be able to present the person's medical card as defense.
Right.
I think they will. I don't think that it's going to prevent an attorney from presenting any meritorious defense on behalf of their client. So criminal defense, it's not going to impact. You're advising somebody after the alleged law violation occurred, as opposed to advising somebody before the law violation. And
Gotcha.
You can't see it because of our screen, but I talk with my hands, and I'm doing all these hand motions while I'm talking. So
it's all right. I do too. And well, unfortunately, depending on who you are in my audience, I haven't had a chance to really say much today because you're the one with all the information about this. So thank you for taking the time out and guiding us through this, because this is a fairly complex issue that was not very clear for people to understand right off the top.
Yeah, there's a lot of people that have heard that the businesses may have an issue with their representation and have run with it down the road saying, I'm not going to have an attorney for my possession of pot case.
Right.
And that's not the situation at all. You certainly are going to be able to get an attorney for your criminal defense.
That's good.
If you're in the state of Missouri and there's no attorney that will represent you in criminal defense because of this, hell, I can't represent everybody all over the state, but call my office. We'll help you find somebody local.
That's awesome. Again, thank you for taking the time out today and helping us work through this situation. I really appreciate you. Your videos are so cool. You're the only attorney I know that does a drive and talk session. It's fun. It's exciting. And being on the other end of that, you never know if the other person's going to get pulled over or if there's a fire truck or something going to blast by. What are we going to see on the road? Guys, audience, you need to check out Pat Talks Law. You can find him on Facebook and on YouTube. He's a great guy and he's really inspirational. Reach out to him, tell him I said hi, and if you need, if you need his services, he's totally available, right?
Yeah. As a final point, I know it's probably not an issue for your audience, but you have to contact your congressman and your senators. Marijuana has to be descheduled federally. If it's descheduled federally, all of these questions go away.
100%. Thank you for bringing that up. That's a very important subject. Do exactly just that. Contact your senators. Let them know, guys, it's on the path to help get this legalized and stop having criminal, like, I want to say criminal injustices served upon humanity. Uh, that's what this is. It's a plant. We shouldn't be locked up over it. Treat it like a tomato, folks. Pat, thank you so much. And you're a beautiful person. I hope to see you again. If there's
Sure.
any other issues that come up, hopefully we can sit down and talk again. Thank you, brother.
Look forward to it. Thank you.